Good afternoon to those of you on the East Coast, and good morning to those of you on the West Coast. My name is Felix Shipkevich, and I'm honored to be joined today with my colleague Yvonne Bowser-Caballero. Today's May 1st. I can't believe we're already on first day of May. Time's flying quickly. And today we will discuss the overview of the latest TSR amendment applicable to all telemarketers and sellers. And I think we have a pretty interesting discussion and informative agenda packed for you today. We'll try to accomplish it in the next 45 minutes or so. Obviously, there's quite a lot to discuss. Also want to give a big thank you to many of those of you who are repeat um, listeners to our webcasts and webinars, and obviously a big thank you to those of you who attended our in-person regulatory workshop on the West Coast about 2.5 months ago. It was extremely well attended, and we hope to see you at future webinars and in-person events. So without any further ado, why don't we begin? And by the way, for those of you who have been following our webinars and educational series, today is the first time we're decided to do it with our webcams on, spicing things up. We usually do these just with voiceover only, but maybe perhaps it's time for a little change. So let's do that. I'll keep my introduction fairly short. I am an attorney. I'm based in New York City. I run a boutique firm based in New York, Miami, and London. Primarily, our staff is based in New York and Miami. I'm personally based in New York, where I practice regulatory work in a variety of sectors, from fintech to debt relief, money transmission, payments, crypto. I teach at Hofstra University School of Law. I recently had a textbook published. In case you want something to fall asleep at night, you could buy it on Amazon. It's great melatonin to go to sleep, as I joke around. But in any case, you probably, I imagine if you're here, you probably know a little bit about me. So why don't I turn it over to my colleague Yvonne?
Hello, everyone. Very excited to have you all join us for this webinar. We've got a lot of great information packed in here. For those of you who do not know me, I have been counsel with Shipkevich for a little over 3 years now. I primarily focus on transactional services within the financial service, debt relief, settlement, fintech industries. I work a lot with licensing. So many people are familiar who have undergone any licensing projects with us, with me, and I'm excited to help you guys learn a little bit more about these record keeping requirements.
Thanks, Yvonne. Yvonne and I have a little joke now. There was an article published last week by the Forbes magazine, and since Yvonne went to UVA for undergrad and I went to Binghamton University, they're both now considered to be the new Ivies because of everything that's going on. So congratulations, Yvonne, for being considered to have gone to a new Ivy. So
Thank you. Thank you.
anyway, let's get into the topics for discussion. Now, I know that we have two phone listeners. Unfortunately, you're not able to follow through with the slides, but feel free to contact us directly by email. We're happy to send you a copy of this presentation. And another thing, just note that typically when you attend the in-person events, I don't pack as much content into the slides that I do for these webinars. We we when we put these together, we pack significant amount of content to the slides, which is not really what I like to do, but I do that because many of you do ask us for slides because you like to keep them and you like to, keep them for your own informational purposes. And they do have a lot of very useful information. So, just try to follow through our presentation. If it gets overwhelming, you could always reach out to us and get a copy of these slides. But in any case, So the topics for discussion, we are going to discuss obviously the rule, general overview of TSR, but the focus really is going to be what really recently changed with the new past TSR amendment. TSR amendments don't typically happen that often, and we'll discuss the timing of these. Uh, then we'll talk about when, who, and what, right? What exactly was passed with this new TSR amendment. And then Yvonne is going to really dive deep into the implementation of compliance. Um, we're going to do our best to give you as much information as possible, but as you can imagine, the information, the subject matter is very dense. There's a lot of information, and so we'll do our best to cover the subject matter as much as we can within this short time frame. Um, you know, Clearly, we suggest that you try to speak with your own compliance or legal staff or your outside counsel in order to dissect this in more detail. So, look, the TSR has been around for almost 3 decades. It's been around since 1995, and it was created by the Federal Trade Commission in order to curtail harmful telemarketing practices. I imagine that the majority, if almost not everyone who's listening to this webinar, understands the purpose of the scope of the the FTC's telemarketing sales rule. The TSR was to prevent fraud and to curtail fraud. Um, Generally speaking, TSR prohibits sellers and telemarketers from using deceptive or abusive telemarketing practices. It requires them to make certain clear disclosures and maintain comprehensive records of their telemarketing transactions. That's a given. Um, and then on the next bullet point, you essentially have the several times that the TSR was amended since 1995. And you see, it wasn't really that much. In 2003, the TSR created the Do Not Call Registry, and it expanded to cover charity calls as well, right? So that's the first time it was amended. In 2008, which was the second time it was amended, prohibited pre-recorded messages in sales and charity calls, right? So that's two. 2010, so that's the third time. That's the one that people and the folks in the debt relief space know very well. That's for obvious reason, requiring prohibition advance fees, right? You you can't take acceptance fees. And 2015 was banning the use of telemarketing for certain payments and mechanisms associated with fraudulent transactions. And the most recent one, 2024, so that will be the fifth time in 30 years. So what you're doing about every 6 years or so, it gets an amendment if you kind of want to average it out. Um, that's that's really where we are, right? 2024. Well, technically, the last time it was 9 years ago, 2015. Now, so why now? What's the purpose of this new recent amendment? Um, well, the main scope, the primary scope, is really to update the record keeping provisions of the rule. The record keeping provisions of the rule hasn't been updated since 1995. That's a long time. Um, I think that's probably the first time I started using World Wide Web. I think there probably are people on this webinar who were not born or very young in 1995. And that's how long it's been since the record keeping provisions haven't been updated. So it's been a while, right? That really is the main crux of the amendment update, and that's something that I would hope that you take away the record keeping changes that have gone into place as a result. Clearly, we have a major change in the past 30 years in terms of technology in the marketplace that has made it more difficult for regulators to enforce the TSR. Maybe not difficult, maybe more challenging. And so the FTC in the proposal stated the primary hurdles in enforcing the TSR in the current telemarketing landscapes are: one, identifying the telemarketing seller responsible for telemarketing campaign, right? So if one is identifying who's the telemarketing seller, right? Two, obtaining the call detail records, right? So one is identifying, two is obtaining the call detail records. And three is linking the content of the telemarketing calls with the call detail rankings to determine which TSR provisions might apply, right? So then they want to basically link the content of 1 and 2 once you identify and obtain that information. And so as a result, the new TSR amendment has expanded the record keeping requirement for sellers and telemarketers so that the regulators, and by the way, regulators doesn't necessarily mean the Federal Trade Commission. That could also be the CFPB. That could also mean the state AG's office, which have the ability to enforce the telemarketing sales rule, by the way, can identify responsible parties and obtain evidence of their telemarketing activities in case there's a violation or in case they suspect there's a violation. Okay. Let's continue on the purpose of this new TSR amendment. And by the way, I start with the purpose because, instead of just diving into it and tell you, which we will tell you, what exactly are the changes, if you don't understand the purpose, then it's kind of like planting a tree without the roots, right? The tree without the roots won't survive. And so I'm giving you I'm planting that tree and with the roots, and I want you to understand the basis, the core of why this was proposed, right? And what's the basis. Now, another component of which we will not go into detail here. We might do another webinar if there's an interest, or you please feel free to email us. We've actually been in touch with some of our clients, but there is a B2B, right, business to business component, and now the TSR is not just B2C, but now there's a B2C component. So in case now TSR has jurisdiction over deceptive telemarketing activities that are B2B, not just B2C. And so that you have to be mindful of, right? So until now, the TSR applied only, the jurisdiction of TSR was, any sales calls, solicitations, any activities regarding, specifically towards consumers. And now you have now the expanded, I guess you could say, implementation of TSR will apply in B2B activities. And that has actually been, interestingly enough, discussed since 2003, right? So it's been around for 1 years, when the FTC considered extending the TSR's protections to B2B call selling, internet or web services, but decided against doing so, not to fear of chilling technological innovation. It did, however, in 2003 note that it will continue to monitor it closely. I want to bring a little cynicism, right? When the government says we'll monitor it closely, it took them 21 years to monitor it closely. But yet here we are, 21 years later, they monitor it really closely. A few presidents later, members, House and Senate changed between Democrats and Republicans, but eventually, I guess it got close enough. Okay, it's just a little cynicism I bring to a lot of these webinars. I guess now it's close enough. Okay. And since then, the FTC continued to see small businesses being harmed by deceptive B2B telemarketing, which is why this new amendment requires B2B sellers and telemarketers to adhere to Section 310A, and we'll go into that in a little bit more detail a little bit later on, about prohibiting misleading statements. So, so this no longer applies just to consumers, and this does apply for activities and marketing materials specifically being extended to businesses. Okay. Now, this is pretty important. And when does the TSR amendment go into effect? So there are two dates to keep in mind. So the amendment will go into effect. The majority of the amendment, right, will go into effect. Let's say majority. Yeah, the amendment itself technically will go into effect on May 16th. And that's 15 days from now. That's pretty close, okay? So May 16th, 2024. That's a very, very important date. However, the compliance with Section 310A, 310.8.5A2, and again, we'll be a little cynical, it's just a little section requires retention of call details, and Yvonne will go into it, is not required until October 15th. So you have about, give or take, about 4 months to kind of get your compliance together to make sure that you have the proper document retention, proper retention of call detail records. That's your sort of grace period, as the rule says, right? So you know, if you haven't thought about maintaining those records when it comes to call details, you should be thinking about it now. I would not put it off, especially with the summer coming up. I love getting calls. I can't wait to get those calls, end of September. Oh, this is coming up and we still haven't figured out how to keep him. So start thinking about it now. But the rule actually goes into effect May 16th. So don't be fooled. And please be mindful that it's just a small part that really is kind of carved out. Okay. Now, so we did the when, right? Who does the TSR amendment affect, right? Very, very broad. And again, right here on the slide, we have all the definitions. It affects the seller. The seller is any person, and obviously person doesn't mean a person, individual. It means also a company, right? In connection with telemarketing transaction provides, offers to provide, or arranges for others to provide goods or services to the customer in exchange for consideration. Basically, look, if you sell a product in connection with a telemarketing transaction, you're subject to it, right? Then you have a telemarketing definition. Any person in connection with telemarketing who initiates, receives telephone calls to or from a customer or donor, right? Pretty straightforward. And telemarketing, well, let's not leave that out. Telemarketing means a plan, program, or campaign. And by the way, a plan, program, or campaign. So that's very broad, right? Which is conducted to induce the purchase of goods or services or charitable contribution by use of one or more telephones, and which involves more than one interstate telephone calls, right? One or more interstate telephone calls, right? So it has to have an interstate call for that also as well. So it covers the who is very broad, very broad. You can't say so let me kind of dumb it down for anybody who is in the debt, let's just say debt settlement space, right? We obviously have many followers in this debt settlement space. It covers your operators, it covers your marketing companies, your front ends, your back ends, whatever you want to call them. It covers them. If you're selling these products, you're covered. Okay, you're absolutely covered. Okay. This means any company engages or arranges for telemarketing will be affected by the new amendment. Okay. Now, let's continue with the who. Okay. And this is really important, extremely, extremely important. If you attended, when Jessica, Yvonne, and I were speaking at our event in Costa Mesa, and when I get up there in front of the audience and I say, like, this is the one thing that I want you to pay attention to. This is one of those things. Please pay attention. Each seller in telemarketing is responsible for complying with the record-keeping section of the TSR. Each seller, let me repeat that, and telemarketer is responsible for complying with the record-keeping section of the TSR. And both are required to maintain their own records unless a prior agreement has been established. Let me break it down. You can't basically say, hey, you're doing all the sales calls, so that's your problem. Well, if someone is doing it on your behalf, they have to maintain their records, and you have to maintain your records, right? You can't just say, you can't keep your head in the sand and say, well, I'm not responsible. But the law allows you to have an agreement established in order to avoid any type of duplicative records. Why? It basically has that reasonable, sensible requirement. Says, look, if you have two parties and one party is being contracted to do sales and marketing, and you can covenant with them to keep those records, right? You can covenant to do them. Obviously, you have to make sure that they keep those records. It's still going to be on you, but there's no point to have duplicative records if you agree. So sellers and telemarketers do not have to keep duplicative records if they have a written agreement allocating responsibility for complying with the record keeping requirement, right? However, note that by written agreement, for example, the telemarketer bears the responsibility for the record-keeping requirements of this section. The seller must establish and implement practices and procedures to ensure the telemarketer is complying, right? So it's not just, hey, we're going to have an agreement and you're done. The seller must establish and implement practices and procedures to ensure the telemarketer is complying with these requirements, and vice versa, right? So it's not like, hey, you're selling products, it's your problem. No, no, no. It's actually that requirement has to go both ways, right? So, and if the agreement is unclear as to who must maintain records, both telemarketer and the seller responsible complying, they both have to be responsible, right? That's really important. Okay. So now I'm going to turn it over to Yvonne.
All right, everyone. So now we have finally gotten to the what. What are these new keeping requirements? So under the TSR's existing record keeping requirements, sellers and telemarketers have been required to keep records for a 2-year period, listing all of the different advertisements and scripts that they have used, a list of any customers or employees involved in actual sales or solicitations, and then a record of express informed consent or express agreements. Really, the previous record keeping requirements just were very broad, didn't give too much detail, only really required call detail records for actual sales of services. The new rule has amended this existing record keeping requirement and increased that record retention period from 2 years to 5 years, except for advertising materials and service contracts, which you are required to keep for 5 years from the date they are no longer in use. So just making sure that you are now meeting that new 5-year retention period. It also clarifies which records are necessary to demonstrate that the person calling has received the consent to call. So it expands upon that expressed informed consent or express agreements requirement, and tells you exactly what you need to be keeping in order to be compliant with the TSR's record keeping requirements. And finally, it specifies the formatting for these records, including how phone numbers should be recorded and maintained, how the timestamps should be recorded and maintained, and call duration. So, what new categories of information does this new amendment require? So, some of the new categories of information are a copy of each unique pre-recorded message, including each call a telemarketer makes using soundboard technology, call detail records, which we have briefly touched on, of telemarketing campaigns. It's this section specifically where they are allowing for the grace period until October 15th. So I will get into a little bit more detail about what exactly they're looking for in those call detail records, so you have a better idea of what types of systems you may need to start looking into to make sure that you're compliant. But it is that section on call detail records, and this includes all calls. This is what is different from the previous requirement. All calls need to have these detail records, even if you haven't actually engaged in a sale of a service. You also need to have records sufficient to show a seller has an established business relationship with the consumer. And we now see a new definition as to what exactly it means to have an established business relationship if you are seeking to reach out to someone who you've already reached out to. You also need to show records sufficient to show a consumer is a previous donor to a particular charity. I know this doesn't affect many of our clients, but for any charities that also need to adhere to the TSR. Records of the service providers that a telemarketer uses to deliver outbound calls. So you need to have clear records now of who exactly you are initiating telemarketing campaigns for, if you are a seller, which telemarketers you're using, and you also need to maintain copies of all contracts between telemarketers and sellers. Records of a seller or charitable organization's entity specific do not call registries. Again, they have listed out specific information that they want you to maintain here. They want to know which registries that you are looking at or accessing when you are looking for that do not call list, and who exactly is subscribed to those do not call registries. We will get a little bit more into that further along. And finally, records of the FTT's DNC registry that were used to ensure compliance, kind of similar to the previous requirement. So the new amendment will, in addition to these, require the retention of other new records to help identify the nature and purpose of each call. So this is what you're seeing more so within those call detail record requirements. You now need to have the identity of the telemarketer who placed or received each call, the seller for which the telemarketing call was placed or received, the goods, service, or charitable purpose that was the subject of the call, whether the call was to a consumer or a business, whether you utilized robocalls, whether it was an outbound call, the telemarketing script or recording that was used in the call. All of these things are new requirements that the TSR now specifically states you must maintain. Telemarketers and sellers must also retain records regarding the caller ID transmitted if the call was an outbound call, including the name and phone number that was transmitted, the records of the telemarketer's authorization to use that phone number and name that was transmitted as well. So you're seeing here, there's a lot of new extensive requirements here. Can you please do the next slide?
Yeah.
Or is there anything you'd
One
like?
thing I want to mention is that I imagine that a lot of this information, as you listening to this, I imagine that some of you might be either slightly overwhelmed or more overwhelmed than slightly. I imagine that a lot of this information is already available, if not in part, maybe even in whole, but some of your telephone service providers or your CRMs that are connected to your telephone service providers, right? Um, and like identifying the name of telemarketer, right? So I imagine that should already be available based on the person who made the call. Like that shouldn't be very difficult. Seller of the organization. I just want to kind of digest this a little bit more because I think that some of these could potentially be viewed as like, oh my God, I can't believe it. But it's actually not as difficult. It's the question is, how do you want to make sure that you start thinking about this now. You don't really have a lot of time, and two, that you're now starting to talk to your both whoever is providing your phone services or whatever CRM, that you are now extrapolating these requirements and thinking about how to record them, right? How to record them now for 5 years, and then for 5 years after the account is gone, and then we could give you all those timelines if you want to contact us separately. Then you don't have to maintain those records after the 5 year expiration. But anyway, a lot of this information should be made available to you technically. You already might have most of this, if not all of this information available. But yes, go ahead, Yvonne.
Yeah, absolutely. So, as well as adding the new record keeping requirements, the amendment includes new format requirements for records containing a phone number, time or call duration, like I previously mentioned. And again, that's not like very difficult to adhere to. It's just making sure that you're recording everything in the proper format. Clarifying existing record keeping requirements to delineate more clearly the information that you must keep to comply with these provisions, and specifying what information is required to assert an exemption or affirmative defense of the TSR. So an example that is given is records of verifiable authorizations, express informed consent or express agreement, consent documents, are to include a consumer's name, phone number, copy of the consent requested in the same manner and format it was presented to the consumer, a copy of the consent provided, and the date the consumer provided the consent and the purpose for which the consent was given and received. So something I do want to bring up here is, there's no, you don't have to record or audio record any of these calls. The requirements aren't stating that these need to be recorded. You simply need to make sure that you're just making a detailed record of the information that they have now clarified per these new amendments.
Let me distinguish that from, for instance, we do work in other areas, for instance, on the equity side and commodity side, where the calls have to be recorded. There are obviously FINRA or NFA rules that require our clients to have call recordings. Here you don't, but the consent portion is very important. And it's so easy to comply with that. I can't even tell you from a compliance point of view, you know, very, very easy to comply. Don't make a big deal about it. If you compare this industry to other industries where you do have to forget about consent, you have to record, and sometimes you have to screen. This is easy to comply. Again, I'm just trying to help for those of you who follow us to understand that some of these may seem overwhelming, but it's actually not as terrible as it sounds as long as you try to digest this and understand, and also if you compare it to other industries. I am hoping. Um, okay, so
So we just kind of wanted to give you a visual here in a chart format of, the previous record keeping requirements and the extent that they covered, and now all of the new additional record keeping requirements that have been added through this amendment. Um, so as you can see here, you now must maintain from 2 years to 5 years. You're still required to maintain copies of all substantially different advertising, brochures, telemarketing scripts, materials. You still need to keep specific information for sales records, including the name and last known address of the customer, the services that were purchased, the date they were provided, the amount paid for the services. You still need to keep records for all current and former employees directly involved in telephone sales and solicitations. And you still need to get, records of all verifiable authorizations of express informed consent or express agreement. So none of those things have changed from the previous record keeping requirements, except for, changing the years from 2 years to 5 years. Um,
and
now-
Yvonne, which of these goes into effect on May 16th, and which of these goes into effect on October
Yeah,
15th?
absolutely. So from the new record keeping requirements, everything under what needs to be included for a record of each telemarketing call, it's the white bullet point on the right-hand side. All of these are the records that, or record identifying information that you must adhere to by October 15th. So it gives you time to put in some sort of processes to efficiently keep that data and record that data.
Okay, and so let's continue. And what about this
Yep.
specific
So this is kind
list?
of just to give you more so of a visual of, how extensive these record keeping requirements are. The new record keeping requirements I had to put onto a separate page. Um, and they give a little bit more information about exactly what you need to now include for consent records. It gives you information about what you need to keep record of if you want to assert that you've had an established business relationship with a consumer. It also allows you to sorry, it also dictates exactly what information you need to keep regarding the DNC registry that was used, and it also dictates those formatting requirements that we were talking about. So it is a lot. It can be overwhelming, but I don't think it is difficult to comply with these. It's just making sure that, you're going through this list, checking things off, making sure that all of these are being recorded, according to the requirements.
Okay.
All right. So how should you prepare? We have kind of touched on this a little bit here and there, but All companies that engage in or arrange for telemarketing their products or services, including companies that engage in telemarketing to other businesses, must be cognizant of this new amended rule. Sellers and telemarketers, like we previously stated, do not have to keep duplicative records if they have a written agreement in place. Just remembering that that written agreement needs to properly allocate responsibility for complying with the record keeping requirements, and have those policies and procedures for whomever is not keeping the records, to ensure that they are being compliant and maintain access to those records as well. Um, Companies should start considering revising and strengthening their TSR compliance management processes in order to mitigate the risk of compliance failures. So, looking at your agreements with telemarketers, if you're a seller, telemarketers looking your agreements with sellers, making sure you have an agreement in place regarding these record keeping requirements, and if you don't, making sure that your individual company has the right processes in order to ensure that these are being properly recorded. Um, Remember, violations of the TSR can carry penalties of over $50,000 per call. So, if you don't want to incur a violation for something as simple as making sure that you're just keeping the right records. So it's important to implement any required changes as soon as possible before the new rule becomes effective next month, or this month. I'm sorry.
So let's talk big picture. Um, I think that obviously these slides are very dense, right? They're very dense, a lot of information. Um, let's talk big picture. Um, One of the things that I've said in the past 10, 15 minutes, I said, well, you can go to your current CRM, or you could go to your current I imagine you probably have a voice over internet protocol provider, VoIP telephone provider, and you could probably get a lot of this information, or your compliance team should certainly start thinking about this now. And yes, you could and should be able to meet these requirements, and it shouldn't be that difficult, right? So Felix, what are you worried about? We got it. We got it. The reality of it is, from experience, and is when things seem to be very easy, it's also very easy to sanction, right? Um, it's you know, it's not that easy to prove something was violated unless it was documentary, right? If you could show something it wasn't kept timely, wasn't documented in a proper format, um, if you have to keep a name of an individual who made the outbound call, if a person was able to obtain the consent, did you check it against the do not call registry? These things are so easy. And when regulators come in, and I'm pretty sure that the attorneys on this webinar, whether you're listening to the recording or whether you're listening to this live webcast, you certainly could appreciate when regulators walk into in person or conduct an audit. They're people too, and they are looking at this in a check the box type of approach. When they get a data dump, right? It's very easy to see whether the company generally has the documents, or are they really missing these things. And when some things are easy to comply with, they're also very easy to violate. And so, in a nutshell, I'd like to end this webinar with the following thought. While these record keeping requirements extend from 2 to 5 years, and they have significantly more to maintain, to record, to keep, your compliance staff or your legal staff will obviously be a little bit more busier, right? And you should take this very seriously. Well, things sometimes seem very easy or reasonably practical to figure out. They're also sometimes very easy to violate and very easy to prove that they're violate. So at the end of the webinar, I urge you to not wait until it's September to start figuring out. I urge you to start thinking about this right now. And I hope you found this webinar informative. And I know that obviously you probably in the past month or so, since month and a half since this rule is finalized, was published in the Federal Register, you probably got a lot of newsletters. We like to do these as webinars. We send out newsletters as well, but but appreciate it. And we have a new webinars coming up later this month, which are going to be very interesting. We hope to see you at our future events. This is our contact information. We're very grateful for your participation and look forward to seeing you at future events. Thank you very much. We'll see you next time.